Good day, everybody. This is Michael Levitis, jurisq.com. We bring you different attorneys, different practice areas in various states. And today we have back with us Jesse Minc and Gary Silverstein from the law firm here in Manhattan, Rosenberg Minc, that handles personal injury law. Gentlemen, welcome back. Thank you for your time.
Thank you, Michael.
Thank you.
In our previous sessions, we talked about construction accidents. We're dissecting the various steps one has to make to get maximum compensation. And now we're up to step number 3, which is discovery. Now, not everybody knows what discovery means. That's why you're here to educate the public. What is discovery in a construction accidents case?
Well, Michael, thank you very much for raising this topic. It's an important element of the winning mechanism in order to obtain maximum compensation for your injuries. Discovery is the free flow of information. It's the information that flows from the plaintiffs, your side, you're the construction party, you're the party that's been injured in an accident. It's the information that flows from you, but more importantly to us, it's the information about the job site that flows back to the plaintiff side. And it's during that phase that you have components that include depositions. Depositions is something that requires an immense amount of preparation with the client, and with and looking at all of the records, the contracts that are there. One of the things that we do at our firm in order to get you the most money possible under a construction case is to adequately and thoroughly prepare the laborer, the construction worker who's been involved in the accident, so that they understand what the deposition is and how it works. And one of the things that we, as experienced, skilled attorneys that represent injured construction workers for many, many years, is develop them and give them information as to how their accident falls within lines of the law. Now, that's a very complex issue for a laborer to understand, but in order for you to prove these cases, you have to develop a theory, a story that complies with the law so that we could get maximum compensation. So, Jess, why don't you explain the best you can in this limited period of time, the efforts that we go through during the discovery phase in order to go and get the information necessary to prove our claims.
Sure. Well, first, there's the discovery of information that happens before you may even have started a lawsuit, and that's going to the scene to take a look, see what you can see, if you can see where the accident happened. Also investigating public records. Oftentimes OSHA, the local Department of Buildings, may have investigated. Those records are available without respect to there being a lawsuit. Then there is, after you actually have filed a lawsuit, you write up a list of requests to the defense attorneys. Those in a construction accident will always include accident or incident reports, witness statements, the daily logs of the superintendent of construction and the site safety contractor. You will also be looking for perhaps plans, different data where you can put the puzzle together of how and why this all happened, and at the end of the day, who's responsible for it. Those are the ways that we go about it. And of course, the most important thing that we do in discovery is to prepare our client for his or her testimony. Your testimony in a lawsuit is evidence. It is evidence that can be used against you, but more importantly, it is evidence that you weaponize against the defendant to prove your case. And we spend a lot of time preparing you to give your testimony, to tell your story in an effective manner so that you can obtain the maximum compensation and make sure your case fits within the parameters of the law that give you special protections here in New York.
See, that I think that what Jesse just said is so vital for people out there to understand. It's one thing to say that you've been involved in an accident. We have to prove it. You have to prove it. You as the injured party, us as the attorneys, we have to prove it. So in order for us to work together as a team to get you those results that you think you deserve, we spend the effort and the time in whatever language you speak. And we've handled immigrants throughout the entire gamut throughout this great
Sure.
city of ours. So wherever you are hurt, whatever your issues are, we prepare you. You're not used to being asked questions by multiple lawyers. You're not used to going ahead and answer questions about your background, your history, your work experience, your date of your accident, the weather, the snow, not snow, what kind of ladder, safety devices. We work through it with you in a very, very significant manner so that at the end of the day, you're going to be prepared and you're going to say to yourself, I was a star today. And that's what we try to go ahead and reflect upon our clients, that they are prepared and that there's no surprises. And that's what we've been doing here at our law firm for a long time.
Yeah, Gary, that's perfect. You said a very important thing. And I want to repeat what Jesse said, where a discovery could be used as a weapon, right? Whatever you say could be weaponized. And Gary, you and I had a session last month. We talked about neutralizing opposing witnesses. I think this goes hand in hand with the discovery, because that's how you get the information to neutralize a witness. Am I right?
Yeah, Michael, that's a great point. When we discussed that at length the last time we met, when you do the discovery process, when you obtain an OSHA report, when you obtain an accident report, a video through the discovery process, photographs, when a guy comes in from the general contractor and says that he was working on a 4-foot ladder, when you have video surveillance that shows it's a 12-foot ladder, or you have an investigative report from a coworker that says that you were working up on a scaffold and that collapsed, and they're saying that you walked off the site on your own doing. These are the kinds of things we're here during the discovery process to protect your interests. And that's what we fight for. And that's what we've been doing at this law firm for over 100 years, fighting for your rights to go ahead and get you that maximum compensation.
Perfect. Jesse, I want to ask you a follow-up question. What happens if you find out in the course of a trial or discovery that the other side did not provide the materials that they had, that they were supposed to provide for you? Can you use that as a weapon against them at trial?
Yes, you can. Under the discovery rules, and especially in New York and in New York federal court, state court, whatever forum you happen to be in, there are rules that specify penalties for failure to turn over the appropriate documents. And we come across this all the time in our practice, and we use it against defendants as much as we can. Specifically, you will write a request for information. A defendant's lawyers, thinking that they're being sneaky, will tell you that things that turn out to be quite damaging for them just don't exist. You then get to a deposition of one of their witnesses who explains, oh, of course we have that thing. And then you ask for it and you get it, and the case resolves, because they knew if you ever got your hands on what it is that they were trying to hide, that would be game over. If, for example, we discover that they have been refusing to turn things over, we can ask for certain sanctions to be imposed on them. Most of the time, what we want is the evidence. We don't necessarily need the sanctions. We want to prove our case, but there are tools to remedy those things, of course. And in the case where a defendant may, by mistake or intentionally, destroy or deface evidence so it's not usable in the trial, there are penalties for that as well. And we certainly are aware of it. We take advantage of them whenever we can to help our clients at the end of the day get the best result possible.
Excellent. Well, gentlemen, Jesse and Gary, thank you so much for not only explaining it to us, but doing it in a way that is interesting, because discovery as a subject could be a bit dry, but you actually brought it to life for us, and we can now understand how it's applicable in real life court situations. And now we're going to come to our most interesting topic, which is the culmination of all efforts, which is the actual settlement. We're going to talk about what goes into settlement, what determines the amount of the settlement, and how to get the best maximum settlement compensation for your injured clients. And again, Today, we are educating, right? We're spending our time to educate the public, and I want to thank the law firm of Rosenberg Minc for that. But if anybody has any specific questions, you were injured, be it on a job or maybe even in a car accident, the best thing you can do for yourself is as soon as possible, call attorneys who do this for a living, day in, day out. And one such firm, premier firm here in New York City, is Rosenberg Minc. The phone number is in the bottom of the screen. Consultation is free. Thank you, everybody. Stay tuned for our next segment, compensation. Thank you.
Thank you, Mike.